Most people don't like talking about estate planning. It feels uncomfortable, thinking about what happens after you're gone. So it gets pushed off year after year, and many people assume they'll get around to it eventually. But here's the reality. If you die without a will, your state laws has one for you, and that default plan may look nothing like what you would have chosen. Dying without a will is called dying intestate. It can create confusion, conflict, and unnecessary costs for your family, and it can delay the distribution of assets, put state law in charge of who gets what, and even increase taxes and fees. Instead of leaving your family with clarity, you leave them with questions and problems and sometimes disputes that can last for years. This isn't just an issue for the wealthy. Whether you have a business, properties, or a modest estate, not having a plan puts your family at risk of going through a costly, time-consuming, court-mandated process called probate. Hi, I'm Brandon Persia, partner and financial advisor at Starboard Wealth Advisors. I take the time to help high net worth retirees and pre-retirees create tax-efficient income strategies and preserve their wealth and retire with clarity and confidence. If you want to make sure your legacy is protected and your wishes are honored, click the link in the description below to schedule a complimentary consultation, and I'll help you review your estate plan and identify any gaps before it's too late. So what actually happens if you die without a will? Let's walk through it step by step, and I'll show you what you can do now to make sure your family is protected. As we often tell clients, and I think it will become clear in this video, your estate plan is your final act of love for your family. Part 1, the state decides who inherits what. Without a will, your estate is distributed according to the intestacy laws in the state where you live. That means the state government and not you decides who gets your stuff. Typically, state laws direct that assets go to your closest relatives in a specific order. First, your spouse, then your children, parents, siblings, and extended relatives. But these default rules may not reflect your wishes. For example, consider a man named Robert who remarried after his first wife passed away, and he has 2 children from his first marriage and 1 stepdaughter from his second marriage. Without a will, state law may direct a portion of his estate to his current spouse and biological children and not to his stepdaughter, whom he raised as his own but never legally adopted. The result? His stepdaughter would receive nothing, even though Robert might have wanted to provide for her. Or consider Sarah, who is a single lady with no children. She has a close friend who's treated like family for decades, and she's passionate about supporting a local charity. Without a will, none of her wishes matter. Her assets may go to distant relatives she hasn't spoken to in years, while her closest friend and favorite charity would also receive nothing. A will allows you, not the state, to decide who inherits your wealth. Part 2, probate becomes more complicated. Dying intestate doesn't avoid probate. In fact, it often makes probate more complicated. Probate is the court-supervised process of distributing your estate to the legally rightful owners. If you have a will, the court uses that document as guidance on how your named executor is to carry out your wishes and distribute your estate. If you do not have a will, the court appoints an administrator to oversee and handle everything and determine the rightful owners of your estate, which can differ from your desires. Further, that administrator may or may not be the person you would have chosen. This creates delays, additional legal costs, and stress for your loved ones. Heirs may wait months or even years for your estate to settle. Meanwhile, they do not have access to funds they need to pay for everyday living expenses you left behind or for emergencies. For example, I've seen situations where a spouse died without a will, leaving property jointly held with his brother. Because there was no clear directive, the surviving spouse was stuck in probate for over a year before they could legally sell or transfer property. That kind of delay is not only financially stressful, but emotionally draining at a time when families are already grieving. Part 3, guardianship for minor children. This is one of the most overlooked but critical consequences of dying without a will. If you have minor children and no will, the court decides who will raise them. Let that sink in. Some court would decide who would then raise your children. You may assume your spouse would automatically become the guardian, and in many cases that's true. But what if both parents die unexpectedly? Or what if there are disputes among relatives about who should take responsibility and become their guardian? Without a will, naming a guardian, the court becomes the referee and makes the final decision. And while judges do their best to choose someone who seems suitable, it may not be the person you would have chosen. For example, suppose a couple wanted her sister, a very responsible parent with strong family values, to raise their children if something happened to both of them. Without a will, the court would instead assign guardianship to an estranged relative simply because they had a closer legal standing. That decision could have been avoided with a simple written document. You see, a will isn't just about assets. It's about ensuring your children and your wishes are cared for by the person you trust the most. Part 4. Taxes and fees may increase. Without planning, your estate may end up paying more in taxes, probate fees, or legal expenses. A will by itself does not eliminate taxes, but it's often the first step in coordinating other strategies like trusts, gifting, and beneficiary designations, which can reduce costs. And without it, your estate plan can become tangled in unnecessary expenses. This is especially critical for business owners. Imagine a small business owner who dies intestate without clear instruction. The business may be tied up in probate, forcing heirs to sell quickly to cover taxes or legal fees. Often that can result in a fire sale, or the business being sold below its true value just to raise cash to pay its bills. Years of hard work and building value can be lost in a rushed, unplanned sale. Estate planning helps protect not just the value of assets, but the efficiency of how they're passed on. In Part 5, family conflict increases. Perhaps the most painful consequence of dying without a will is the potential for family conflict. Without clear instructions, family members may disagree about who should inherit what. I've seen families torn apart by disputes over estates. Sometimes it starts small, arguments over who gets sentimental items like jewelry or furniture. But without written instructions, those arguments, emotions, and old sibling rivalries can escalate. In some cases, siblings stop speaking to one another. In others, legal battles consume both the inheritance and the family relationships. The will does not solve every issue, but it provides clarity. Tells your loved ones your wishes and allows you to make decisions while you're here, instead of leaving your loved ones to figure it out and fight over them later on. So conclusion, what happens if you die without a properly legal will? The state where you live decides who inherits your assets. Probate becomes more complicated and expensive. The court determines guardianship for your children. Your estate may face higher taxes and fees, and your family could be torn apart, dealing with conflict instead of clarity. The good news is, it does not have to be that way. By taking a little time and having an estate attorney prepare a proper estate plan, you control what happens to your assets, who cares for your children, and how your legacy is preserved. Remember, your estate plan is your final act of love for your family. If you haven't created or updated your will in the past 5 years, or since your now adult children were minors, now is the time. So let's talk. You can click the link in the description below to book a complimentary consultation, and I'll help you take the first steps toward protecting your assets and your family. Remember, at Starboard Wealth Advisors, your financial destination is why we're here. Thanks for watching, and if you found this helpful, make sure to watch our other videos for more clear, no fluff, retirement guidance, or contact us for a simple phone call or a Zoom call. Thanks for watching today.